relationship between obligation and agreement. So this is perikatan, as I said. Obligation is perikatan, hukum perikatan, right? We are talking about hukum perjanjian, but hukum perjanjian yang menghasilkan perikatan, So an obligation, perikatan, is a legal relationship between two parties on the basis that one party has the right to demand something from the other party, and the other party is obliged to meet the demand, the claim. Article 1233 stipulates that the obligation was born from an agreement or from law. Okay, so please always have this in your hand, in your table, on your table, because we will keep on looking on it. This is our Bible. For the contract law, this is our Bible. For the business law, I mean, for the people, for you who would like to focus on business law, this is the Bible also. Never forget it, never not using it, because it's very important. Code, this is code civil. 1233, tiap-tiap perikatan dilahirkan baik karena persetujuan, baik karena undang-undang. Persetujuan is also translated as perjanjian. So this is subjekti, right? Subjekti is having is changing it from the perjanjian to perikatan, But other translation called it as perjanjian. So let's just make it simple. So tiap perikatan dilahirkan baik karena persetujuan, baik karena undang-undang. So there is an obligation arising from an agreement. There is an obligation arising from the law. Now, what is an agreement? And if you can move to the 1234, just a minute. So that was 1233. Then you move to 1234. Tiap-tiap perikatan, every obligation is to deliver, to do something, or not to do something. When you someday learn about contract drafting, when you have experience in drafting a contract, the contract is all about what you have to deliver, what I must do before I deliver, or what I'm prohibited to do until the delivery, and when you are dealing with acquisition, sell and purchase of shares, sell and purchase of property, that is complex deal, not just a simple one-off transaction. These things will be heavily related and drafted in the contract. So 1233, 1234, and then the agreement itself is 1313. What is that? Suatu perjanjian adalah suatu perbuatan dengan mana satu orang atau lebih mengikatkan dirinya terhadap satu orang atau lebih. So suatu perbuatan, an action, which one party binds himself to one other party or more. So that is the important term, I think, perbuatan, that is intentional. There is not like you don't know about it and then suddenly you are bound to it. No, it's not like that. When we are talking about agreement, there is an intentional action. You intend to do it. You are willing to do it. So there should be intention and there should be a willingness, and this will relate to the purpose or cause of an agreement, of course, that we are talking that we will be talking when on the validity of an agreement. So you can see it here, relation between obligation and agreement. Obligation, agreement. Obligation causes that's the source, from an agreement. This is the first source, this is the second source, and then creates an obligation. The relationship between the obligation, the agreement, is that the agreement causes the obligation to rise. The agreement is the source of the obligation, in addition to other sources. So when you enter into an agreement, you make the parties create an obligation to emerge. Yeah. So if we are talking about an obligation, the obligation is more abstract. Yeah, because you cannot see it. Yeah. Well, agreement, it doesn't mean you can see it all the time. Yeah, because agreement can be made in writing, can be made in verbal, right? And as students, try to be more sensitive in your daily activities. Yeah, everything, many aspects of our daily life is related to contract, actually. Yeah. Well, we don't call it contract, but I mean it is a contract. Yeah. When you go to the mini mart and then you buy things, right? You buy noodles, you buy chocolates, you buy breads and everything. That's a sell and purchase. Yeah. That's a contract. There is a contractual relationship between you as the customer, and the mini mart as the seller, right? It is a transaction. It is a contract. But on that case, of course, the contract is verbal, because you don't write a written agreement just to buy groceries, for example. Yeah, but it is a contract. Yeah, and we will talk about sell and purchase. You have to be more sensitive. When is the agreement reached? Yeah, when is the sell and purchase contract reached actually between the mini mart and me? Yeah, when do I need to pay? Yeah, what is when is the property, meaning the groceries that you are buying, are becoming my property? Yeah, are transferred to me. Yeah, those are the things are interesting. Yeah, so that's why what I'm suggesting is while you are doing this class, yeah, and while you are studying other legal concepts in your study, be more sensitive about your daily activities, because contract is everywhere actually in our daily life. And the other example is like the transport law. When you enter into a bus or a train, right? Even before you pay the ticket, or in a microlet misalnya, for example, or bus, you don't really have a ticket. Yeah, you just enter. But when you enter, you have to pay. Yeah, where that obligation comes from? That's actually from the sell and purchase of service. Yeah, there is a service for the bus driver to transport you, and in return you have to pay. That is your obligation. Yeah, that is your obligation. So it's in our daily life. Yeah, when I'm saying be more sensitive, think about it. Yeah, people don't think about it, right? People just enter the bus, pay the money, and that's it. But you are law students and you are studying contract now, so think about it. Yeah, just don't take it for granted. Yeah, because if you only take it for granted, you will not improve as a legal scholar. Yeah, I mean, if you want to understand the law deeper, better, you have to think about it. Yeah. Of course, many people will not think about it. Yeah, and of course, maybe many law students don't think about it. Yeah, but it's good to think about it. So it trains your mind. Um, how is the contract formed? When is the contract ended? Yeah. For property, when the transfer takes place. Yeah, because all of those things, you will still be involved when you are dealing with complex transactions like shopping malls, for example, or coal mining project, for example, or toll road project, for example. Yeah, everything will be related to that thing. Yeah, when the contract is formed, when the property is transferred, what are the obligations before the transfer, and everything. So be more sensitive. So an agreement creates an obligation, right? It's more abstract because we cannot see it. The agreement is more concrete because we understand under the law. Yeah, it's regulated under the law. It's intentional. Yeah, it's intentional that you enter into the bus to be transported. It is intentional that you enter to the mini mart to buy groceries. Yeah, nobody forces you to do it, but when you do it, then it is willing, it is intended by you as the prospective buyer to buy. So you intend to enter into sell and purchase agreement with the mini mart, right? So there is an intention. After you intend it, it will create an agreement, and an agreement will create an obligation. So there is something that you have to do. Yeah, you have to pay for the purchase price. So there is no major difference between agreement or contract. Yeah, some say it's agreement, some say it's a contract. Both can mean the same, but can be different also in terms of subjective. For example, said that contract is an agreement in writing. Yeah, but in common law, a contract does not always be interpreted as a written agreement, actually. But that's fine, I think. A contract can be the same as agreement, but contract can also have different meaning, which is a written agreement. Okay, let's just follow it. And then the agreement as the source of an obligation. There is also another source, which is the law itself. Yeah. And when we are talking about this source of law, there is two outputs. Yeah. The first output is perbuatan sesuai hukum. Yeah. Action according to the law, or perbuatan melawan hukum. Yeah. Action violating the law, or we call it unlawful act. Yeah. Unlawful act. So that's from the law. The law places an obligations on parents and children to give each other a living. Nah, di 625, 625 Civil Code. This is the obligation arising from the law. And if we can see in the 1354, if a person willingly, by not having an order for it, represents the affairs of others, then he is obliged to continue and settle the matter until the person represented by his interests can do the business himself. Okay, let us see. Ya, jika seorang dengan sukarela dengan tidak mendapat perintah untuk itu mewakili urusan orang lain dengan atau tanpa pengetahuan orang ini, maka ia secara diam-diam mengikat dirinya untuk meneruskan serta menyelesaikan urusan tersebut, hingga orang yang diwakili kepentingannya dapat mengerjakan sendiri urusan itu. Ia memikul segala kewajiban yang harus dipikulnya seandainya ia kuasakan dengan suatu pemberian kuasa yang dinyatakan dengan tegas. So these are the things when the law rises or causes an obligation to rise. Yeah. If you are do it willingly, kan? Willingly artinya nggak ada yang suruh ya. Nobody forces you to do it, nobody instruct you to do it. Ya. So you are free not to do it. Yeah, you are free not to do it. Yeah. But when you decide that you do it, that you would like to do it voluntarily, then you are bound to it. And you have to finish it. Yeah. So this is the legal action that is according to law. Yeah. You are not violating the law because you represent this person without his consent, for example. Yeah. Because you do it for the interest of this person. Yeah, so it's a good thing to do. So when you decide to do it, you have to complete it. Yeah. So there are some other things that we can discuss about this concept. It's called Zaakwarneming. But before that, let me a bit return to the law only. So the Zaakwarneming, the 1354 is very important to understand. But the obligation arises from the law is a lot, right? The relationship between parents and children is one thing. The relationship between husband and wife is also another thing. The relationship between the employer and the employee is also another thing. Even though the fundamental thing is through an agreement, yeah, but there is also an obligation under the law which the employer must do to the employee. For example, like a payment of BPJS Kesehatan, payment of BPJS Ketenagakerjaan, payment of BPJS Dana Pensiun. So there is all regulated under the law. Yeah, the obligation is arising from the law, not only from the employment agreement. Yeah, even though the employment agreement does not regulate about the obligation about BPJS payment and everything, the employer must do it anyway. So that is the obligation. Yeah, so that is the obligation arising from the law. A lot of things. Yeah, a lot of things. Those are just the simple examples of it. So I will move to the Zaakwarneming, voluntary representation. Yeah, you can see also from the 1352. We learned before that the obligation is arising from the agreement or from the law. It's 1233 of ICC. Yeah. In 1352, you can see it here. Perikatan-perikatan yang dilahirkan demi undang-undang timbul dari undang-undang saja atau dari undang-undang sebagai akibat perbuatan orang. So when I talk about the obligation of payment of BPJS and everything, that's the timbul dari undang-undang saja. Yeah. But if you represent voluntarily other person's interest, that is perbuatan orang, ya, sebagai akibat dari perbuatan orang. So if we continue to 1353, it is said that perikatan-perikatan yang dilahirkan dari undang-undang sebagai akibat perbuatan orang terbit dari perbuatan halal atau perbuatan melanggar hukum. So in here I hope it becomes clearer that the Zaakwarneming is the halal action, ya, perbuatan halal, ya. It's not violating the law. When we are talking about unlawful act, you have to go to 1365. 1365 is the legal basis for the unlawful act, ya. So that is not perbuatan halal, ya. That is perbuatan melanggar hukum, ya. Some call it as perbuatan melanggar hukum, some call it as perbuatan melawan hukum, ya. But I think the more used term is perbuatan melawan hukum, ya. I think that's more used in the court proceedings. So 1365, tiap perbuatan melanggar hukum, nah, subjekti usus melanggar hukum, ya. Perbuatan melanggar hukum yang membawa kerugian kepada seorang lain mewajibkan orang yang karena salahnya menerbitkan kerugian itu mengganti kerugian tersebut. Ya. That is if you refer to the 1353 again, ya, perikatan yang lahir terbit dari perbuatan halal atau dari perbuatan melawan hukum. The halal action refers to Zaakwarneming, ya. The non-halal action or the unlawful action refers to the Unlawful Act 1365, yeah. Both creates an obligation, yeah. Even though there is no agreement in Zaakwarneming, there is no agreement in Unlawful Act, yeah. An Unlawful Act is not about agreement. The Zaakwarneming is not about agreement, yeah. It's different. Both concepts are different than, for example, like lease agreement, sale and purchase agreement, transport service agreement. It's different. But even though it's not an agreement, it's an action. we call it as halal action or legal action, and illegal action or unlawful action. That also creates an obligation. That is the fundamental concept. Why then, when there is an unlawful act, the other party that suffers because of that unlawful act can file a claim against that party doing the unlawful action, because there is an obligation arising due to that particular action, yeah, whether it is legal or illegal action. But that does not mean everyone can enforce that right, yeah. Of course, if we are talking an obligation or perikatan, this is not an absolute right, yeah. Like I said about hak kebendaan, about property right. This is a relative right, yeah. So obligation is still particularly relevant to particular other person, yeah. So that kind of obligation that I'm saying, it's not like a universal obligation. No, it's not like a universal obligation, like a human rights. Yeah, human rights is universal. So the obligation is also can be characterized as universal. But this is not a universal obligation. This is a particular obligation between person and person. So even though there is no agreement, but when a person violates the law and then make the other person suffers because of it, that is called as unlawful act. And this damaged party or suffered party can file an unlawful act claim against the other party. So legal and illegal or unlawful, yeah. So Zaakwarneming is stipulated in 1354 to 1357. You can look into it, yeah. We will move to understand more. It is done voluntarily without gaining power, meaning like without instructed to do it, representing the affairs of others with or without that person's knowledge, yeah. Even though that person understands or knows it, That's also fine. Obliged to continue and complete the matter, act according to the law. So not violating law. Yeah. So this is I think, an important difference between legal action and illegal action or unlawful action. Yeah. And Zaakwarneming can happen in many relationships, right? Between the owner of the house and the servant, or other people, maybe our neighbor understands that the house is empty and then take some precautions, some actions to take care of our house, something like that, yeah, with or without our knowledge. That can happen everywhere, actually, the Zaakwarneming concept. Even in the most spatial situation, and it's very interesting. I don't know whether you have learned the company law, maybe you haven't, but we understand that a director is the rightful party to represent a limited liability company, right? But a director is appointed and having their title for a certain period of time, right? Maybe it's 3 years, maybe it's 5 years. Yeah, it's either 3 years or 5 years normally. What will happen if this director is still acting as director after his tenure is lapsed? If we don't have the Zaakwarneming concept, one may immediately say that, oh, this is that is incorrect, right? That is unlawful. What the director has done after the expiry period of his tenure is unlawful because it's not legitimate, right? One may immediately say that, yeah. But Zaakwarneming is not like that, right? Zaakwarneming says if you represent other party and your action is according to the law, yeah, it was fine, yeah. So even though the expiry period happens, it doesn't automatically create that person doing bad things or unlawful action. Yeah, because it might happen that the general meeting of shareholders haven't been convened to decide the extension of tenure, right? It might happen like this during pandemic suddenly, or during disasters. There will be lapse of period, but the director itself must take care of the company, right? If there is no other directors, for example, and the tenure is lapsed, can the director just disregard everything and do not do anything about the company? It doesn't make sense, right? The director must act in good faith to take care of the company that he manages before, even though the tenure is lapsed. Of course, unless the director is to be removed. Yeah, that's another story. Yeah. If the director is removed by the general meetings of shareholders, so it's terminated, right? Di PHK, yeah, it's terminated, and then this director is still regarding himself as director, as a legitimate director, and then sign this agreement, that agreement on behalf of the company, that is of course unlawful act, and that is also a criminal act. Yeah, the dominus and gestor. Yeah, dominus is the one who is represented, and gestor who is representing, who both have rights and obligation carrying out Zaakwarneming itself. Yeah, these are the the rights and obligation. This is the guester's rights and obligation, meaning the party who is voluntarily represent the other party, yeah, the reimbursement of all costs, withhold what dominos belongs to until the compensation is paid, yeah. Obligation, complete the management. Even though the dominus dies, guester must still complete until it can be taken over by the heirs. Yeah, guester must take care of dominus. So once you take care of it, you cannot stop until you are requested to stop. Yeah, you cannot just, if you would like to assist someone, you do it until it's done. Yeah, you don't do it half willingly, half-heartedly. Yeah, when you decide to do it, you have to do it until it's done, until the dominus can take over, the dominus comes back home and everything. But then the dominus, the one who is represented, of course, must compensate all that this guester have done. Yeah, because everything is for the dominus. This is like a proxy relationship, hubungan kuasa, ya, proxy relationship. When I said proxy relationship, I refer to the hubungan kuasa. So, yeah, as attorney, as authorized, of course, all the expenses for the interest of the authorizer, pemberi kuasa, yeah, must be borne, must be paid by the authorizer, yeah, because everything is for his benefit, not for the authorized benefit, or not for the penerima kuasa, kan, tapi untuk pemberi kuasa. Okay, now the dominus right and obligation. The concept is still the same, yeah. Demand that guester do the management, request submit the report, request give dominus a calculation, sue guester for any losses, or even is able to sue. So as a result of the error or negligence, yeah. So that can happen also. So yeah, if there is an error or negligence. So being a guester or someone who is representing the other party's interest, the guester will have to be also careful about it. So when then it is ended, has completed the management of dominus interest, hand over dominus interest management work which was done but not yet completed to dominus, who had been able to take care of his own interests. Yeah. So either you complete or either you deliver it back when the dominus is able to take care his own interest. Okay, a bit about this. I referred to 1365 before, so please read and please have in your hand the Indonesian Civil Code, yeah, because from time to time we will read it, we will refer to the provisions under the ICC and get used to look into it, yeah, so you will not be confused when you read the ICC. Like I said, it's the Bible for the business lawyers. It's important to be used to read the Indonesian Civil Code. So any unlawful act that brings harm to others obliges people for the wrong to issue the loss, indemnify it. Yeah. So we learn about obligation arising from the agreement and obligation arising from the law. And from the law, there are two types, right? From the legal actions, from the illegal action or unlawful action. The lawful action is Zaakwarneming, yeah. The unlawful action is under 1365. So under the 1365, the elements of unlawful act are 5, yeah. There is an action, yeah. This is similar to the agreement concept that we talk about, yeah. There must be an action to enter into an agreement, right? So there is an action also for unlawful act, and the action is unlawful, yeah. This is different than Zaakwarneming. The action is lawful, but unlawful act, the action is unlawful. How can I say? How can I differentiate the lawful act and unlawful act? How can I do that? Well, it's simple. The lawful act is my action does not violate the law. Yeah. When someone does unlawful act, that means that action violates the law. Which law? Any law can be. Yeah, which law? Any law. Can be against the company law. Can be against the hukum memaksa, or what is that? Obligatory law under the civil law. That can be hukum memaksa. Yeah. It can be violation of employment law. Yeah. It can be violation of mining law, for example. Yeah. So that is unlawful. Yeah. And the similar concept you can see in the criminal action. Perbuatan melawan hukum. Yeah. So there must be an action that is breaching the law. Yeah. To be considered as unlawful act. But this is not enough. Yeah. This is not enough. And when we are talking about unlawful act, we can also refer to the an old decision during the Dutch era, Hoyeraad something. Yeah, they expanded the meaning of unlawful, not only violating the law, but also violating the appropriateness, kepatutan, and also justice even, dan keadilan. Ya. So the meaning of unlawful is not only against the law, yeah, but against the decency, against the justice that can be considered, or that can be used as the ground to file a claim of unlawful act. Yeah. So that's the second point. Yeah, but we are not done yet. There is still 3 remaining points. There is a fault. Yeah. There is a fault means, yeah, there is an action, the action is unlawful, and it is your fault. Yeah. Tiap perbuatan melanggar hukum yang membawa kerugian kepada seorang lain mewajibkan orang yang karena salahnya menerbitkan kerugian itu. Ya. So there is an unlawful act. Yeah. And this unlawful act brings losses to the other people. Yeah. And then obligates these people due to his fault. Yeah. There must be a fault also. Yeah. If it is unlawful, most probably, of course, it is a fault, right? So the third point must not be hard to prove. Yeah. If it is an unlawful act, yeah, it is your fault because you should not supposed to do it. And there is an injury. Injury, this is the losses. Yeah. Whether there is actual loss or not. Yeah, because sometimes, well, in our life, maybe people do unlawful act everywhere, right? Breaching the red light, ya, melanggar lampu merah misalnya, or melanggar lampu merah, lalu apa, many other things that people do violating the law, but that doesn't mean it always damaging us, right? It doesn't mean what he did damages me, yeah. But when it does, then we have the right, yeah, as the damaged party to file an unlawful act against him, yeah. So of course, the elements of injury, of loss, or of damage must be proven. There should be an injury, yeah. Because if it is not an injury, there is the 1365 is not fulfilled. The elements to say the other person is doing unlawful act or doing what has been stipulated under 1365 is not fulfilled. And if it is not fulfilled, then it's nothing. And the fifth point is also very important. There is a causality. Ya. Karena dibilang, because the 1365 said, karena salahnya menerbitkan kerugian. Causality, cause and effect, right? Sebab dan akibat, ya. Because of your action, because of your fault, then these are the consequences. Because you do this, this happens. It will mean that if you don't do it, this will not happen, right? But since you do it, this happens. So cause and effect. Cause and effect, yeah. Since you punch me in the face, I got bruises in my face, right? Yeah. Since you violate the company law, the GMS violates the quorum and the consent provisions that the GMS must follow, for example. Since you do this, because you do this, this happens. Yeah. Since you do this, this happens. Jadi sebab akibat, ya. Cause and effect. Cause and effect. Yeah. So it's not easy. Yeah. Sometimes there is an injury, but it's not because of me. Ya mungkin, well, it's not easy to give you an example for it. Maybe someone reaches the red light, and then the other person is shocked because of it, and then it crashed the car to someone else's car. Well, it still can be regarded as cause and effect, right? But it's hard to prove. It's hard to prove. While in like punching your face case, it's a lot easier to prove, yeah, because you punch it, then it got bruises on the face, yeah. So that is the understanding. Yeah, this is a very brief, but very important, yeah. So agreement is the source, law is the source, right? These two sources creates an obligation. An obligation in this regard is perikatan, yeah, perikatan. And for the law as the source, there arises legal action or lawful action and unlawful action. Yeah, unlawful action is 1365. Yeah, you see the 5 elements. Yeah, those elements must be proven to declare that an act is unlawful. Yeah, the same applies for Zaakwarneming. Yeah. There are elements, of course, yeah, that have to be proven if the other party challenges that this is not Zaakwarneming, yeah, this is an illegal act, yeah. So there will be a analysis between unlawful action elements and analysis of Zaakwarneming's elements, yeah, because, well, I don't know, and if like my previous example about the director, the director tenure is expired, and there is no other director, and this director acting in good faith to represent and take care of the company. Maybe there is a shareholder challenge the director, right? And maybe the shareholder doesn't like what the director did, challenge his action as unlawful act, right? So this shareholder will have to prove that the director's action is unlawful based on 1365, while the directors himself saying as the defense, yeah, I'm not doing anything unlawful. What I'm doing is all lawful, just for the best interest of the company. So there will be the debate, and there the judge will decide.